So another federal court ruled that the federal laws on possessing machine guns are in fact a violation of the Second Amendment. But AG Bondi and the Trump administration continue to argue against the Second Amendment in this case that is now heading to oral arguments. So let's break down what is happening in this critical challenge. Now, really quick before we jump in this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm's an amazing company. They make great supplements, protein powder, pre-workout, all of that I use when I work out. But also one of the cool things about them is they're pro-freedom, pro-America, and they support the Second Amendment. So if you want to get great supplements and support a pro-freedom company, check out 1st Phorm using the links down below. And if you order something using my link and it's $50 or more, you will get a free 4-pack of energy drinks. As I mentioned in the intro, a federal court recently dismissed a machine gun possession charge using the Second Amendment and the recent Bruen decision. This is a huge win, striking down machine gun restrictions as a violation of the Second Amendment. There have recently been 2 federal district courts who have dismissed a machine gun possession conviction based on the finding that that federal law is a violation of the Second Amendment. The most recent decision came out of a Mississippi district court issued by Judge Carlton Reeves in a case called U.S. v. Brown. And that case is currently pending in front of the 5th Circuit. However, that case that's currently in the 5th Circuit cited to and heavily relied on a case that we've talked about before on this channel and we're going to be focusing on in this video, which is the U.S. v. Morgan case. That Kansas Morgan decision is currently in front of the 10th Circuit Court of Appeals. It's up for oral arguments. However, the United States government is still arguing against the Second Amendment, and they're still arguing that that decision should be reversed. Currently, like I mentioned, oral arguments are set for July 8th. However, the Trump administration is still making those anti-gun arguments. Now, the facts around this case are that Mr. Tamori Morgan is charged with 2 counts of possessing a machine gun in violation of 18 U.S.C. section 922-0. Specifically, he is charged with possessing an Anderson machine gun and then also a machine gun conversion device, which was a Glock switch. It's the possession of those 2 items that got Mr. Morgan charged and convicted, and he moved to dismiss the possession convictions based on the Second Amendment, and he tried to use the Supreme Court's Bruen decision, which came out 6-3, and redefine the type of analysis, or really set the type of analysis once again, that should apply to Second Amendment cases. On review, the federal district court agreed with Mr. Morgan. They found that defendant argues that 18 U.S.C. section 922-0 is unconstitutional facially and as applied to him. Defendant first argues that under the first step of Bruen, the plain text of the Second Amendment applies to his conduct of possessing machine guns. The government argues to the contrary, pointing to language in Heller that suggests that the unconstitutionality of machine gun regulation would be startling and that the Second Amendment only applies to weapons that were commonly used by law-abiding citizens at the time of the Second Amendment's enactment. When looking at the Supreme Court's precedent in Heller, the court here found that the government relies on Heller to argue that machine guns are not covered by the plain text of the Second Amendment. The Heller language cited by the government is unavailing. First, the government's interpretation of Heller relies exclusively on dicta. The court here states that machine guns were not at issue in Heller. Second, they state that the government's interpretation would run directly counter to the essential analysis in Heller, which is just as the Fourth Amendment applies to modern searches, the Second Amendment applies to arms that did not exist at the country's founding. So the court rejected the federal government's arguments that Heller supports the machine gun law and the restrictions here against Mr. Morgan. The judge went on to state that suffice it to say that the weapons at issue in this case are bearable arms that under Bruen's first step are covered by the plain text of the Second Amendment. The judge then reviewed the federal government's historical analogs that they put forward, and he tried to see if there was a tradition or history to justify these types of machine gun restrictions, but the court found that the government did not meet that burden and did not put forward enough historical evidence to support this restriction. Now, it's important to note that in this Morgan case, the federal government put forward very little evidence to try to justify these types of federal laws. Instead, they seemed to kind of get lazy and they thought that the analysis, wouldn't really even get to the historical review. They thought maybe they would just win at the first step and the court would find that these types of arms are not protected arms under the text of the Second Amendment. But, they were wrong. And also they put forward so little historical evidence that the court here also ruled against them. One thing to note is that the district court issued its decision narrowly only as it applies to Mr. Morgan, but it does open the door for more as-applied challenges like we saw happen in the Fifth Circuit, and if this case stands, it would open up even more of those challenges. After losing at the district court level, the federal government then appealed to the 10th Circuit Court of Appeals asking for a reversal of that decision. Mr. Morgan filed his response to the 10th Circuit, and he argued that the narrow decision by the district court should be upheld. In the beginning of his brief, Mr. Morgan's attorney points out that the federal government is now trying to kind of pull a fast one, and they're trying to modify this appeal and bring in even more evidence. Mr. Morgan's attorney argues that the 10th Circuit should reject and ignore all of those new historical examples since they were not actually in the record and from the district court, and all the 10th Circuit is supposed to do is review whether or not the district court got its analysis right. So one of the main arguments made by Mr. Morgan and his attorney on appeal is that the district court came out in the right way. They came to the correct conclusion, especially based on the limited evidence that was presented by the federal government. They argue that the federal government does not now get to supplement the arguments and bring in more evidence since they lost at the lower court level. Instead, the 10th Circuit should only review what was in front of the district court and only determine whether or not the district court came out to the right decision based on what was presented to them. Now, despite the new Trump Second Amendment executive order that was issued and the new 2A task force that was established by AG Bondi, the Trump administration is still making anti-gun arguments in this case, and they're still arguing against the Second Amendment as it applies in this specific challenge. So they claim to be pro-Second Amendment. They claim to have this new task force to address these types of lawsuits. However, this specific lawsuit is proceeding forward to oral arguments, and you still have the Trump administration filing briefs very recently in this case, still arguing against the Second Amendment. In their recent brief, the Trump administration argues that contrary to the district court's holding, Section 922O's prohibition on possession of a machine gun is consistent with the Second Amendment. Machine guns are not in common use for lawful purposes like self-defense. And Section 922O is consistent with the nation's historical tradition of regulating a variety of dangerous and unusual weapons. Morgan fails to effectively rebut the government's arguments. He wrongly contends that the government failed to preserve various arguments on appeal. He tries to avoid the Supreme Court's clear holding that the Second Amendment does not protect firearms not typically possessed by law-abiding citizens for lawful purposes. And he advocates an improper standard that required the government to identify founding-era laws regulating firearms based on their rate of fire. This court should reject his arguments and reverse, they argue. So that is still the Trump administration. Maybe there's still some Biden administration holdovers who have not been removed from this case, but it appears that the Trump administration has not stepped in on this challenge. Maybe they're not aware of it. I would assume that they're aware of it. But you still have them making these types of arguments, and the new 2A task force has not stepped in and stopped these types of arguments. So it's unfortunate that AG Bondi and the DOJ, maybe have holdover attorneys potentially still making anti-gun arguments in this case. But this is one of those things that, is still out there. It is moving towards oral arguments. It's a win that we had at the lower court level, and we would love to see stand. But you still have the Trump administration advocating against the Second Amendment, and they're arguing for the reversal of that lower court decision. My hope is that the 2A task force steps in soon like they did in other cases and put an end to these arguments and step in, before the July 8th oral arguments and prevent the Trump administration from arguing against the Second Amendment during those oral arguments. That would be a very bad look for the Trump administration if during the oral arguments, attorneys within the DOJ are arguing against the Second Amendment. Of course, that would not align with the executive order and, probably would not align with what the new 2A task force was, set to actually do with these types of lawsuits. This is a strong win that we would love to see stick, but unfortunately, you still see some anti-gun arguments being made by the Trump administration here in the 10th Circuit machine gun case, but also in the 5th Circuit machine gun case as well. It seems like maybe the Trump administration doesn't want to get involved in the challenges or stop these types of arguments, or maybe they're just simply not aware of them. I, don't believe that they're not aware of them, but, this is something that we need to make enough noise about so that they finally stop these types of arguments. So like I mentioned, the 10th Circuit oral arguments have been set for July 8th in this critical machine gun possession case. We need to make enough noise about this so that the Trump administration steps in and doesn't argue during those oral arguments that machine guns are not protected arms. So as we get more information, as it develops, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.